Hey, good afternoon, everybody, today. And thank you, everyone, for joining us on today for another topic being brought from the Crisis Management Deliverable Channel of the COVID-19 Response Unit. As Nancy today said, it's about litigation exposure in the post of a COVID era.
Thanks, Ken. Hello, everyone, and thank you for attending the webinar today. We have a great panel for today's webinar with attorneys from Faegre, Drinker, Biddle, and Reith, who are going to be discussing litigation exposures in the post-COVID era. We're going to take questions at the end of our panel discussion. Before we get to the panel discussion, I'm going to provide a brief overview of our forensic and litigation services practice. Our forensic and litigation services practice works closely on a regular basis with attorneys in various types of litigations. Our forensic and litigation services group is comprised of two different but very similar service lines. The forensic part of the group performs accounting investigations in the public, private, and government sectors. These services include fraud investigations and white-collar investigations, among other services. Typically, these investigations result from breaches of contractual requirements, improper conduct, financial statement accounting anomalies, among other things. Some examples of the types of projects that our team is engaged on involve financial statement fraud, employee misappropriations, white-collar fraud, asset tracings, and audit committee or board of directors investigations. We also provide what's called litigation services. Our litigation services group includes damages expert witnesses who testify in federal and state courts, alternative dispute venues such as arbitrations and mediations, as well as we serve as neutral arbitrators on matters. Our litigation services team provides consulting and litigation services for both plaintiffs and defendants in cases. And they typically involve complex commercial damages, lost profits analyses, intellectual property infringements, business valuations, and economic damages calculations. Some examples of litigation matters that we're engaged on include forensic and fraud investigations, purchase price disputes, shareholder disputes, patent infringements, and breach of contract matters, such as employment agreements, professional services agreements, and supply agreements. The services that we provide from the Forensic and Litigation Group, it's not industry specific. Our Forensic and Litigation Group has provided forensic services in most, if not all, industries. Our expertise is in the quantification of damages, which translates into any industry. For example, we may be hired as the damages expert in a complex matter that involves a shareholder dispute or a breach of contract, or some type of infringement of a patented technology. We're typically just one of many experts working on the matter. There could be an industry expert, a marketing expert, as well as experts on the technology at issue. The damages expert is almost always the last expert to testify at trial, and his or her testimony is linked to all the factual evidence and expert testimony that precedes his or her testimony. From a client perspective, we work closely with attorneys, insurance companies, public and private companies, and governmental agencies. In litigation matters, we are primarily hired directly by an attorney on behalf of a client. In forensic investigation matters, there are times that we may be hired directly by an insurance company or directly by a government agency or a private or public company. These forensic investigations may wind up in court and litigation, at which point we'll provide testimony regarding our findings during the forensic investigation. So why do companies' attorneys hire a forensic accountant? Experts are typically a necessity in a high-stakes litigation and in fraud investigations. In litigation matters, experts are crucial for assisting counsel and the client with litigation strategy. Our forensics team is usually brought in early in the litigation process to help counsel with things such as interrogatories for the other side, document request lists, and deposition questions. Expert testimony that's given out of our group is necessary because the expert provides objectivity. A client will have opinions of their business and the specific litigation that are very important, but those views are usually subjective. Having an expert opining on the issue at hand adds objectivity and independence and credibility to the opinions. Experts also provide specialized knowledge and experience in the matter. Experts in multiple areas typically fall short in one area, so it's important to have an expert that's focused primarily on damages. A good expert is a teacher that's capable of teaching a jury or a judge about a complex issue. In the forensic accounting space, we're hired to teach the fact finder about an accounting or damages concept. So it's crucial for us to be able to take complex financial and accounting issues and translate them to a jury of lay people so that they can understand the issue. With the current pandemic, there is going to be many issues that are litigated, and as accountants, we need to understand the impact to our clients from an overall business perspective, as well as the accounting impacts. One example of these impacts is the disruption of clients' supply chains. During the current pandemic, I think everyone has experienced the fragile nature of the supply chains in our economy in our everyday lives. Just yesterday, I read an article in a fraud magazine that cited to a survey performed by travelers of manufacturing companies. Some of the interesting statistics in this survey was that 30% of companies have their primary supply located in an area prone to severe weather. 49% rely on a single supplier for 25% of their materials. Over 50% of the respondents were not sure if they had a trusted network of backup suppliers, and 51% had a single distribution center. As you can see, supply chain exposure is subject to high risk of business disruption and fraud. Today, we're going to be discussing these types of supply chain issues, as well as employment issues and financial disclosures related to COVID-19. We have a great panel of attorneys from Faegre, Drinker, Biddle, and Reith today who are friends of the firm. Several of our offices and practice groups have worked closely with attorneys from Faegre, Drinker on a number of matters. Faegre, Drinker is a full-service national law firm that has a footprint that is similar to Citrin Cooperman. Our panelists are going to cover 3 areas today: contractual issues, including supply chain exposures, employment-related issues when workplaces begin to reopen, and securities law issues and financial disclosures related to COVID-19. I have the pleasure of introducing our panel of Faegre, Drinker attorneys, and I want to first thank them for helping us out today with this program. Our first panelist, Rick Coe, is the co-chair of the commercial litigation group at Faegre, Drinker. Rick defends companies' antitrust matters and other complex commercial disputes, including claims arising from mergers, acquisitions, and commercial practices. Known for distilling arcane business and accounting issues into arguments that persuade judges and juries, Rick is a trusted advisor to Fortune 50 companies, financial services companies, pharmaceutical companies, universities, and other organizations. Rick is also a Navy veteran, and his pro bono practice focuses on the representation of veterans. I can say I've experienced Rick's naval experience firsthand, as I have worked with Rick as an expert witness on several matters. I'm lucky to say that I've not been the subject of Rick's methodical, detailed approach of impeaching an opposing expert's testimony during cross-examination. Also, sometimes I think Rick was an accountant in his former life. Second, we have Dan Aiken. Dan is the regional partner in charge of Drinker's Philadelphia office. Dan defends employers facing class action and individual lawsuits and helps employers protect their businesses through enforcement of restrictive covenant agreements. In addition to representing employers as lead counsel in litigation and at trial, Dan works with clients to ensure that their operations comply with applicable employment law and best practices in order to minimize employer liability. Our next panelist is Beth Diffley. Beth serves as co-lead of Faegre Drinker's capital markets team. She is also on Faegre Drinker's Women's Leadership Committee. She is an accomplished and pragmatic advisor to public and private clients on corporate and securities matters, including capital raising transactions, public company reporting and compliance, corporate governance, and mergers and acquisitions. She's advised clients on major transactions and critical governance and disclosure. And so our first question for today is for Rick. Rick, what types of commercial disputes have you been seeing, and what type of provisions and contracts are important in that litigation?
Thanks, Joe, and thanks for the kind introduction. What you didn't tell everyone is that you feed me all the questions for my cross-examinations, which makes it a lot easier. And thanks to everyone for giving us the opportunity to speak to you guys today. We're seeing a lot of cases, and a variety of cases related to COVID-19, including cases filed against universities that have moved to distance learning, personal injury cases against businesses that have reopened, and lawsuits against insurers for business interruption insurance. But I'm going to focus on a subset of that litigation related to commercial disputes or contract disputes. Some of the examples of the cases we've been working on in this space are landlord-tenant disputes and disputes with suppliers. As I'm sure you've heard, there are reports of 80% of retail tenants and 40% of office tenants failing to pay rent in April and May. And we've been speaking with landlords and tenants about their rights and obligations. We've also been working with some businesses in the food supply chain who are having issues either meeting their supply obligations or are unable to obtain the supplies they need to operate their business. So what do we tell clients who call with questions? The first thing we tell them is that they should look at their contracts, and specifically look at their contracts and try and find one of these force majeure provisions. And I knew force majeure was a hot topic in the legal world, but I was listening to a podcast last night, and the actor Don Cheadle was talking about force majeure. So I'm guessing a lot of people on this call have heard about it, and certainly a lot of your clients have heard the phrase. And we're going to talk very briefly about what it is and how courts treat these types of provisions. So there's no standard force majeure provision, but they generally include a list of events that either will or will not excuse performance under the contract. For example, a contract might say an act of God, a governmental act, or even specifically a pandemic or quarantine excuses performance under the contract. Most real estate contracts or leases include a force majeure provision, and on the slide here is an example of one from one of our clients' contracts, and I've highlighted a couple of the events in this force majeure provision that might apply to COVID, governmental laws or regulation, or acts of God. Supply contracts are less likely to contain a force majeure provision, and if they do have one, they are more likely to vary, depending on, among other things, the industry. For example, some of our agricultural clients have been through something like this before with pandemics that have affected livestock but not people, like swine flu or avian flu. So contracts in that industry are more likely to address pandemics. So how does a court look at one of these force majeure provisions? Well, they generally view them very narrowly. If an event is not listed specifically, it generally will not be covered. If pandemic is specifically listed, I think your clients can assume the provision will apply, but courts are generally reluctant to add to the list or expand the list. For example, this act of God phrase in this clause on the screen is not defined, and the court will likely look at the other items listed and determine if they are the same type of COVID-19. Just to provide one example, if all the other events are weather-related, like hurricanes, tornadoes, or floods, a court is unlikely to rule that an act of God or COVID is an act of God. I think there will be a good amount of litigation over this act of God phrase, but I think your client should know that the outcome may vary depending on the specific force majeure provision in their contract. Even if one of these force majeure provisions does apply, for example, even if it does have the word pandemic, your client should look at the rest of the agreement to see if there are any other provisions that it should worry about, like a notice provision, a duty to mitigate, and also look specifically at whether all the obligations under the contract or only some obligations were excused. this force majeure provision, even if it applies, might not be a get out of jail free card for your clients. Okay, I think that's it for this slide, Joe.
Thanks, Rick. Our next question is for Beth. Beth, in this highly uncertain environment, our clients face substantial challenges in preparing financial disclosures and reports. What are some of the traps and where should we focus our attention as we review to help our clients mitigate litigation risk arising from disclosure?
Yeah, absolutely. Thanks for having us today. Q1 was incredibly challenging financial reporting period for many companies. And I think this is true for private companies as well as public companies. With the tremendous uncertainties related to the ongoing pandemic, not even being reflected in necessarily a completed quarter's results, but having an intense and pervasive impact on their businesses. And unfortunately, those challenges continue, the uncertainty continues, seemingly remains just as great in Q2, and I don't see it going away too soon. Plus, most companies are going to have to be reporting a completed quarter that has been highly impacted by COVID-19, by the pandemic, by the restrictions on operations, and all of those kinds of things. And so what we see is that disclosure, the nature of the disclosures we're putting out really has changed and has to change. Whereas we typically relied primarily on historical data as key predictors of future performance, we're really no longer in a place where we can prepare financial disclosure primarily by rolling forward Q1 to prepare Q2, right? And that's just hard. A lot of it really has to be focused on expectations and plans for the future, with the overlay that there's so much about it that's uncertain and that we can't know. That is what regulators want to see, it's what investors want to see, it's what financing sources and creditors need to know. And so companies and their advisors need to anticipate potential exposure to regulatory and private litigation should those forecasts prove inaccurate. And of course, at some level, they're going to be inaccurate. So as I work with my clients in reviewing their financial reports and disclosures, and as you do the same, there are a few areas that obviously you're already going to be focused on. I mean, on this slide, I'm sure the things that you're already thinking about, but where you can help them work through the disclosure to hopefully mitigate risk of bad impacts on litigation after the fact. Where these forecasts are an important component of the financial reporting, certainly the impairment analysis, the going concern analysis, all these recoverability and valuation questions. It will be helpful, I think, to focus the disclosure and discussion on the inputs that were used in reaching the valuation, on the assumptions and estimates used, and really think about, I mean, I think we're going to see, and we probably should see, a little bit more sensitivity analysis in the footnote or MD&A disclosure about the potential variability in the operating results in the valuation based on potential changes in the assumptions. Really what you're trying to do here is establish for the reader an understanding that assumptions and actual results can differ and that they have some idea of the scope of that. I think we'll also see kind of heightened materiality, newly material items, more discussion about some items than we typically have seen. For example, trends in liquidity, ability to access credit facilities, more extensive disclosure of the debt covenants themselves. Frankly, if there's a substantial risk of a default or of being able to access that liquidity facility, that should be clear enough to a reader. We're certainly going to see more going concern disclosure as well. And for example, I mean, just recently in an SEC comment letter, there was a comment about impairment disclosure. And I think this is one that frankly should merit more real estate even if you reach a determination that while there was a trigger event, there was no impairment. There was a comment letter to Carlisle companies where no impairment was found because fair value exceeded carrying value. But the SEC wanted the company to indicate essentially how much the fair value exceeded the carrying value. Like, was it substantial? If not substantial, tell us by how much and why. You know, this is disclosure that helps a reader understand and see a better picture of the risk of future impairment. So these are the kinds of things that are a bit different than what we've seen before, but putting that full story out there. So if we end up with a worst case scenario in the future, there's been some information there that could help an investor or a financial statement user potentially see that coming. That it will be very important, I think, as well. I always consider risk factor disclosure to be a key insurance policy almost in defending securities litigation claims. And that should be a real focus this quarter. Most of our clients, I expect most of your clients, updated their risk factors in Q1, and they should all really be revisiting them and taking a hard look at them this quarter. More changes are likely to be necessary. These are the areas where you might be wanting to add some of the disclosure to discuss the items that Rick and Dan are discussing today. But as a general matter, you know, we've got to update risks that are currently described as hypothetical if they've become actual. We've got to update changes to reflect changes in management's expectations, update a general COVID-19 risk to something more specific, update specific risks with further development. So this is going to be a tough quarter again. Thankfully, SEC's released some pretty helpful guidance on COVID, on helping companies assess and disclose the evolving impact of COVID on their business. There was disclosure topic number 9 that came out in March or April, and then just last week was 9A. And the Office of the Chief Accountant has released similar statements. I generally use these and recommend clients use these kind of as a checklist for preparing their disclosure. It's very helpful. And I will say, I attended a meeting with senior staff of the SEC a month ago, including Bill Hinman, the Director of Corporation Finance. And he said that they were going to issue this guidance that they issued last week. And that he really expects companies to thoroughly update their disclosures and to provide substantial forward-looking disclosure. They think that this is critical, and while it's critical and it's useful, it certainly involves some risk because, as I mentioned, you know, results may differ. So your help in putting the full story together is really critical. Next slide.
Thanks, Beth. This question's for Rick. Rick, how will courts sort out commercial relationships, such as those with suppliers and landlords, if the contract is silent about what happens in a pandemic? And how do you expect that to change over time, especially as most states are starting to ease restrictions on businesses?
Good question, Joe. We've been getting a lot of calls from clients asking that very question. Clients want to know, is there any defense to a breach of contract claim if there is no force majeure clause? And they're saying it's impossible or nearly impossible for us to comply with this contract. What do we do? For example, what do you do if you booked a bunch of hotel rooms for a conference, but your employees can no longer travel to the city where the conference is being held? What do you do if you're a meat packer and you can't process all the cows that are being delivered to your plant, or you can't, meet the supply obligations you have to your customers? So there are a couple of legal doctrines that might come into play to excuse performance, even if there's no force majeure provision in a contract. And I'm going to talk about two. The first is impossibility, and the second is frustration of purpose. For this impossibility defense, sometimes also called an impracticability defense, to apply, you need to prove four things. One, that the risk was not foreseeable. Two, that it changes a basic assumption of the contract. Three, that it makes it impracticable to comply with the contract. And four, you were not at fault for the event. So with respect to the first element, foreseeability, I think that's pretty obvious. Neither party knew COVID was going to happen, but I think it will be interesting as time goes on. You can't sign a new contract after COVID hit and say, I have this impossibility or impracticability defense, because the courts will say, well, you should have negotiated that into the contract. The second element, the basic assumption requirement. A lot of courts have ruled that it's not a basic assumption of contracts that economic conditions are going to continue. And the fact that a contract is less profitable because, for example, a supply has become more expensive does not excuse performance. And this is related to this third element. What does this word impracticable mean? So it's obvious, legal term, but it means it doesn't have to be literally impossible, but it does have to present an extreme and unreasonable difficulty, expense, injury, or loss. And courts, again, have been historically reluctant to excuse performance when a contract becomes less profitable because they are worried about opening up the floodgates. But they have left open the possibility that they will excuse performance when a change in price is, quote, well beyond the normal range. So obviously with COVID, we have a situation that is well beyond the normal range. So it'll be interesting to see if courts are more open to this argument that performance should be excused because of changed economic conditions. And then finally, the last element relates to fault. Pre-COVID, there are a lot of cases saying that an inability to obtain financing, for example, does not excuse performance because it's either your fault that you could not get financing, or you should have included a financing out in your contract. But again, we're arguably in a different world where clients are unable to obtain financing for reasons that are no fault of their own. It'll be interesting to see how courts address this factor post-COVID. And while courts have been reluctant to excuse performance based on changed economic conditions, they have been much more receptive to arguments based on government orders. So I think a lot of your clients are going to have a pretty good argument that performance was excused while their business was shut down by the government. But the problem with this argument is likely going to be that a lot of these closures either were temporary or are going to be temporary, and there is a concept of temporary impracticability. So a government order might only pause performance or delay performance, not completely excuse performance under a contract. Turning quickly to this frustration of purpose defense, the textbook example was something we all had in law school 100 years ago. Someone rented a bunch of hotel rooms to attend a coronation parade. The king or the queen got sick, and the court said, well, the renter didn't have to pay for the rooms because the whole point of the contract was to see this parade that didn't happen. So I think this applies most directly to the conference or hotel room example I gave you earlier. The difference with impracticability is that performance doesn't have to be impossible or difficult for one of the parties. It's more an argument that performance just doesn't make sense for one of the parties anymore. I think the question in these cases is going to be whether both parties knew that this was the purpose of the contract. I think in the conference example, there may be a good argument that the hotel, if it was hosting the conference, knew the client was only renting the rooms so its employees could attend the conference, and if the conference is canceled, the client might have a good argument that it shouldn't have to pay for the rooms. But in most cases, the connection is going to be less direct. For example, I've been getting a lot of calls from my partners who have kids in college, and they already signed a lease for an apartment, but the college is going online and they don't want to pay the rent on the apartment anymore. Maybe there's an argument in a small college town that the landlord knew why the student was renting the apartment, but I think it's going to be a harder argument to make. And just in general, I think, a lot of these arguments are going to be difficult to make because unless you can tie them to the government order, they're going to be related to changed economic circumstances. And at least pre-COVID, that was a pretty tough argument to make, Joe. I think we can move to the next slide.
Thanks, Rick. We're going to move on to an employment question for Dan. Dan, we're starting to see businesses open up their offices for employees to return. What are the legal implications and tips that employers should be following as they open up for business?
Yeah, thanks, Joe. So I start at the very beginning with, what are the state and local orders saying? And they're all changing, right? They're in Pennsylvania where I am, they're changing kind of based on, progress in number of cases, and they're changing gradually, right? And so of the orders are allowing returns back to offices, places of business, really on a gradual basis, in a percentage. There's usually a percentage of how many people can be back in the office, those types of things. Always start with the order, and it's just because New Jersey's going back doesn't mean New York is going back, and then think about local orders in addition to state orders. And the first question is, who is going back? Who do we need back? And what we're seeing a lot of are surveys by employers to their workers asking, do you want to return? Are you comfortable returning? When would you be comfortable returning? Sort of, what conditions would need to be in place for you to feel most comfortable to return? And that's not asking permission. Certainly employers can say, hey, we're back in the office, assuming the local order permits it. But it does give you some cover either way if you're taking the temperature, and it's bad. That's a bad analogy. If you're figuring out where your employees are in terms of their comfort level. And so when I look at all of this, we're in this world where we don't have clear standards or guidance from any governmental agencies. We really don't. And so I look at all of this, and when I'm advising clients, I say, when we look back on what you did, can we say we were reasonable and as careful as possible? And so that's why I start with the order. That's why I start with the overall comfort level. And then we kind of work up to, what that's going to look like. So something that's, I think, really common for most employers is screening, temperature checks, and daily verifications that the employee isn't experiencing any of the known symptoms. Now, temperature checks had been a controversial thing, but now they're not. The EEOC has come out and said, look, given the pandemic, a temperature check is okay. Previously, it would have been a medical test, a medical examination under the ADA, the Americans with Disabilities Act, and that would have been pretty severely restricted. Now they're commonplace. I think everyone is doing them. And I think typical. I don't think they cover all of the symptoms. So you have a lot of employers who are saying, okay, I want my employees to verify in some way that they don't have any symptoms. And this goes back to how careful are you being? Are you doing everything you can? Certainly there are going to be employees who aren't as rigorous in terms of verifying that they don't have the symptoms. But the employer, you kind of look back, the employer at least has to ask, right? And if they know that there are symptoms, then take some action. And so the verification has been coming in a few different forms. So is the temperature check. Some temperature checks, some companies are doing it in kind of a self-administered way. So part of your verification would be that, yes, I took my temperature and no, I don't have any other symptoms. And, yes, I was below 100 degrees. And then others are taking temperature at the door, more or less. Just a note on that. If a company is keeping a log of people's temperatures, which is generally a good idea, so that you have a record of the person and their temperature when they came in. Again, going back to the general liability issue of, were you as careful as possible? The other thing is that log is a medical record, and that needs to be kept confidential. And it should really only be people with a need to know who are both administering the temperature checks and keeping the records and having access to the records. So just like any other medical record, those should be kept separate. And these are the types of, if you're having conversations with your clients, it can come up pretty naturally, right? You would say, oh, what are you guys doing? Are you doing any screening? Oh, who's handling that? Some people are hiring third parties. Some people are doing it themselves. These are all conversations that can kind of lead to more and more information and a broader discussion about what they're doing. Antibody testing, I'll get to the punchline, is a no. I know people are really hopeful about antibody testing, and that that will demonstrate who has had the illness, and then therefore who is safe. The EEOC has come out and said these are not acceptable medical tests to require of employees. You could make it voluntary. I won't get into that. That's probably an hour-long discussion itself, but it's just another touch point, and it's definitely a no. And then finally, you have the employees in place. What does that look like? What are you doing with your workstations? Are they apart? Are you building partitions, plexiglass, all of that stuff? We're seeing tight control, certainly in our firm, as we start thinking about it, we're seeing tight control of how people are getting into the building and how people are leaving. Often that has staggered start times and end times for many, so that you control certainly the elevator population, as well as just your general flow. And then many are cutting off their food and beverage service as another precaution. There's a couple reasons to do that, including that these buildings have been sitting empty for a long time. And so just, having access to all of that, the coffee machines and all the lines that need to be cleaned, in addition to food and beverage service just being another touch point, we think, for spreading the virus. I think we can go to the next slide.
Thanks, Dan. Rick, what type of exposure are companies likely to face in commercial disputes, and how do you expect that these disputes will be resolved?
John, I think the most obvious type of damages are the payments that are due under the contract. If a client doesn't pay rent for 3 months, the landlord has a claim for that rent that wasn't paid. But some of your clients might think that's the limit of their exposure, and that might not be the case. So I'm going to at a high level, go over some other types of damages that might be recoverable. One might be for the cost of cover. If a client was supposed to get 100 gallons of hand sanitizer for $1 per gallon, but had to find another supplier that charged them $20 per gallon, he might be able to get the difference in price as damages. Similar type of damages would be reliance damages. Maybe a customer had to spend time or money to find another supplier. Maybe the contract allows the client to get his or her attorney's fees reimbursed. And then, maybe the big bogey is always going to be whether a client can get or a customer can get lost profits. For example, say the client in the hand sanitizer example couldn't find another supplier and couldn't open a restaurant and arguably lost 4 weeks of profits. They might have a pretty substantial claim. Now, I think those lost profits damages are going to be pretty difficult to prove in this environment. One, a lot of contracts have limitations on consequential damages that might apply to lost profits. Two, I think there's going to be a good argument by people like Joe that these damages are speculative. How do you separate out the profits you lost as a result of people not coming to the restaurant because they're scared of getting COVID versus the amount that you would have had before COVID? And then third, can a client prove it did everything it was required to do to mitigate its damages? Couldn't have just gone out and find just to use soap instead of hand sanitizer, for example. We haven't been seeing a lot of these cases yet. I think everyone was kind of predicting there would be this flood of litigation. It hasn't really hit yet. There was one case filed, I think last week. I have sort of the caption up here from this case with Victoria's Secret. It sued its landlord for its Herald Square location in New York City, trying to get out of a lease that requires it to pay about $1 million a month in rent, which is a lot of underwear, obviously. It made these frustration of purpose and impossibility arguments that we talked about earlier. And one thing that was kind of interesting is after this litigation was filed, the landlord made a public statement that it had made several offers to defer rent. And we're seeing a lot of that. I think that's a reason a lot of these cases haven't been filed yet, is that if the only damages are, for a few missed rental payments, it's probably not worth the cost and expense of litigation unless your rent is $1 million per month, obviously. Landlords and tenants are, I think, kind of waiting to see how this plays out. If it's a 3-month interruption in rent, but the landlord is going to keep the tenant, the landlord probably wants to work with a tenant because it's going to be hard for that landlord to find a new tenant or replacement. On the other hand, if the tenant's going out of business, then the landlord has a collection risk. I think ability to pay will be a pretty significant factor in a lot of COVID-related litigation. Client might have a great damages claim, but if the counterparty to the contract can't pay it, it might not be worth litigation. Everyone knows lawyers are expensive. Clients have to pay Joe too, and even though it's kind of against our best interest, it's probably worth the clients exploring, whether there's a business solution to these supply chain disruptions or other business interruptions before they pull the trigger on litigation. That's all I got on that one, Joe.
Thanks, Rick. Our next question is for Dan. Dan, how should clients and employers be assessing furloughs and layoffs that were already conducted? And how should they be planning for additional layoffs?
Yeah. So I think what we saw certainly in March and heading into April were just on a really wide scale, employers conducting furloughs and many layoffs, but really a lot of furloughs. And it was just look, we have nothing for you to do at home, can't work from home, kind of depending on the situation. And so basically you're furloughed. And what a furlough is, just for kind of a working definition, it's not a termination of employment. It's meant to be temporary. And, one aspect of it is that most benefit plans allow for people to continue their benefits while they're on furlough. And then there were plenty of layoffs too, and we'll talk about those. So if I were to be speaking to a client who said, oh yeah, we conducted a furlough of, let's use a nice round number, like 200 people. And let's say they have 800 employees. We furloughed 200 employees. So what I would want to know is, how was that communicated? Was it a letter? Did the letter have a promised return to work date? Was it flexible? There's not a right answer to either one. They should generally be flexible, but not always. And how long was that? And then, times past, have you called any employees back from furlough? And we'll get to that in my second bullet, why that matters in my second bullet. And then when I look at layoffs, I'm looking at, okay, how many were laid off? Did you offer severance packages? A little bit of a legal issue here is some severance packages for people over 40 need to have a few more bells and whistles, including a very long consideration period of 45 days and a disclosure about who was included in the layoff and what the job titles and ages were. Employers miss this when they don't have good guidance. And so if you hear about furloughs and layoffs, learning a little bit about these things will lead to, I think, some more questions. And so especially if you're looking at, if we're valuing a company, if we're doing some due diligence on a company we're buying, I would, and we do a fair amount of this, especially in private equity world, we're going to be looking at what happened between March and let's say now and maybe later. All heck broke loose, and how did they respond, and did they miss anything along the way? And so furloughs and layoffs are going to be areas where we're really going to focus in and see if they see what they had in place and how they communicated it and how they handled it. So one big issue when you're doing that, when you're kind of looking back, is whether what they did triggered some WARN issues, right? And the WARN is basically a layoff statute. There's a federal statute, and then there are many state statutes. And what WARN says is, look, if you have a mass layoff, which is either 500 people or 33% of your workforce, then you need to give 60 days notice of the layoffs. It's essentially 60 days of pay, and it needs to be 60 days in advance. And so that's pretty simple. If it's just a straight layoff and you give 60 days notice, and notice would say, hey, you're going to lose your job in 60 days. What happens though is these furloughs that were meant to be temporary, it hasn't happened yet, but if they go beyond 6 months, that's a WARN issue that sneaks up on you. Because if the furlough turns into a 6-month furlough, that's really an employment loss. And so it could turn into a mass layoff and therefore a WARN issue where you were required to give 60 days notice. And it gets very sticky, and it can be on a rolling basis, essentially a 30-day rolling basis for when this happens. And so you don't just count one day, you count essentially 30 days. And so if a company is about to have another layoff and they already have employees furloughed, then you can see how the math can kind of start to push together, and you need to worry about different buckets of employees. And so I've lately been asking the clients that I advise for just a spreadsheet showing, how many people were furloughed on a certain day, how many have come back, that type of thing. We start to kind of get into it. It's very much a numbers game. And so when we talk about future layoffs, one big issue that I'd want to watch. And also, I'm a big proponent, unless the company just doesn't have the money, of making sure we get severance agreements in place on those layoffs. One, I think, thing we've seen, we handled layoffs starting back, big time back in 2008, had a big jump for about 3 years there. People sign their severance agreements. And so if you really want to control liability, and if you're looking at a company that had layoffs, seeing severance agreements in place is really valuable. Okay, next slide.
Thanks, Dan. As we move forward through the pandemic and into the future, many businesses are going to be offering hybrid work from home and office arrangements. What advice can you give to clients and employers regarding this new hybrid work environment?
Yeah, so I think a couple things are really coming to mind when I'm talking to clients. Number one, we all kind of ran home. Some people literally with a monitor under their arm, and sort of now what, right? People are really planning for the long haul. And so what companies are doing is they're looking at their expectations around, okay, when do you need to be available? How are we tracking your time? And specifically, how are we accounting for things like lunch and meal breaks when it's sort of the honor system if you want? And then how do you do that? And so I don't want to go on too long. I would say if I were talking to a client about this, I would want to know what they're doing with their hourly workers, if they're auto deducting for a lunch or a meal break. So if Joe works 8 hours and we expect him to take a lunch at 1, are we automatically taking off the 45 minutes from his time without asking? And that's not illegal in itself, but it can cause real problems. And so that's an area where we're also kind of asking and probing to see if we have any issues. That's another thing we'll be looking at when we do due diligence too. And then the next frontier is really tracking productivity. A lot of this is already existing in the logistics area. So plenty of trucking companies have already been putting black boxes on and tracking their drivers. I think you're going to see a move or an attempt to move to a sort of individual black box. And we all know there's plenty of tracking ability. So I think you're going to see employers trying to track that productivity of the home office. And then, what they're going to do with it, who knows? I mean, there's data, and then there's what do you do with data? And then one other point is, when we talk about reasonable accommodations, certainly for the Americans with Disabilities Act, there was often a a kind of bright line that there was no reason for me to let people work from home just because of their disability if I wasn't doing it already. We would often say, no, it's important that people be in the office. I think the game is changing on that. So I think you're going to see this having to allow people to work from home, even when people are returning as an accommodation, is going to become, I think, much more commonplace and very difficult to argue against, unless you have some data or experience where it just didn't work for that job, or it just didn't work for that employee, especially who demonstrated that they actually can't do the job from home. That's all.
Beth, the last two questions are for you. We've got a couple minutes here. The first question is from a financial statement and disclosure perspective. How is the SEC and other regulators looking at our clients' disclosures, and what is the likelihood of enforcement action?
Sure. So I know we're running out of time here. I can keep it short, but this is important stuff. I mean, obviously, I talked about earlier that the SEC is expecting forward-looking disclosure, and that raises new risks and challenges when it turns out that the company failed to accurately predict the future. Thankfully, the SEC's guidance makes it clear that the SEC does not expect to second-guess good faith attempts to provide investors and other market participants with appropriately framed forward-looking information. So if we help our clients put together well thought out and thorough disclosure, that will be helpful. But what is good faith, of course, and of course only our clients really know that. But it's certainly helpful to have been rigorously prepared and vetted and subject to controls. Hinman, at least at the Division of Corporation Finance, pretty specifically told me that the staff is looking at companies' earnings releases, investor presentations, listening to their analyst calls, all of that in addition to the reports, the 10Ks and 10Qs. And, it seems pretty reasonable to him and to the SEC that where we're seeing consistent messaging, that's a good evidence of good faith. That and obviously that's a lot of what you do is you're looking at in your reviews and the disclosures and all the backup for it to ensure that the information is consistent. And that's something we as advisors can help our clients do. But it's also, consistent with what's been reviewed by the board. If it appears that companies are changing their messaging for their audience, you may have some trouble. And to the extent that there's a reason for different disclosure to be different for different audiences, that should be clear and reflected and obvious in the rationale and in the document. When it comes to potential enforcement action, we do expect the SEC to focus on that consistency of disclosure across public statements, including as it relates to certifications for participation in COVID-related aid programs like PPP loans. So that is something might be worth looking at as part of your review procedures. And we also know that the Division of Enforcement's fraud group believes that this current climate is ripe for exposing pre-existing accounting or disclosure improprieties or to lead companies to engage in improper conduct. So they are conducting a pretty systematic review of the public filings. And these risks, but structural risks like excessive debt, extreme leverage, and possible liquidity disruptions are indications that there might be issues there. And they'll be looking for disclosures such as impairments that may attempt to disguise previously undisclosed problems as kind of COVID related when they're really not. So your experience and professional skepticism in reviewing this disclosure to see the real story is helpful. I mean, when I see facts like this, I often get a litigator involved in helping me with the disclosure. We know this is risky. We know this would look awkward if we don't get the story right. Put on our plaintiff's hat, put on our regulator's hat as we work on the disclosure to really ensure that the rationale is clear. Obviously these are going to be focuses of your review. Next slide. I'll just really quickly cover SEC's Staff has not provided guidance for COVID-related adjustments on non-GAAP, not specifically, except to say that if you include adjustments, you should explain why management finds the measure useful and how it helps investors assess the impact of COVID-19, as well as generally complying with the non-GAAP disclosure requirements. We have not seen, at least in first quarter, many adjustments in this space. I'm not sure we will. Certainly don't think it would be appropriate to make an adjustment for some of the most obvious impacts of COVID, which is lost revenue. You're not going to put that back up on the top line. So I'm not expecting a lot of adjustments there or non-GAAP COVID measures. While we see some of those provisions being worked into credit agreements, not so often in the public disclosures just yet.
I want to thank everybody for attending, and a special thanks to our friends at Favorite Drinker. I hope this gave everyone an overview of some of the litigation issues that our clients are and potentially will be facing. If anybody has any follow-up questions, please send me an email and I'd be happy to connect you to any of the panelists at Favorite Drinker. Thanks everyone and have a nice day.